फुल स्क्रीन वाला हो गया था?
हाँ हो गया।
सब हो रहा है कभी देख के डेमो
सर ज्वाइन कर ले उनको, एक्सेप्ट कर ले उनको, एडमिट कर ले।
कर लेंगे?
कर ले
हाँ कर ले।
व्यू कर ले इसको, व्यू
एडमिट
कर ले।
करो, अगर हुआ ना तो एक बार म्यूट करके आई टॉप पे।
आप बोल सकते हो हम ज्वाइन कर लेंगे। आ रहे हैं ना? आ रहा है कुछ? हेलो 1 2 3 4 हेलो।
अच्छा मुझे एक चीज देख के बताओ, वो वाला सुनो, एक चीज मुझे फाइनलाइज करके बताओ कि ये जो स्पीकर है ये इसके साथ
कनेक्टेड है, टोटली कनेक्टेड है
सर। तो मैं उसे बोल रहा हूँ विल बी एडमिटिंग इट।
यस।
आवाज आ रहा है टेंशन नहीं है इसका।
सर एक बार
किसी Guys, we'll be starting with the session. Please maintain pin drop silence throughout the session. When we open up for question answer, only then speak and one by one. Okay? Maintain the drop.
एडमिट कर लेना।
Sir.
इथं वरती आता त्यांना
मैसेज है चैट फोकस कर दे। एक बार माइक ऑन।
I hope you can see me and hear me. I don't have any smoke from your side yet. But if you can see me and hear me, now I can hear you.
Okay, hi. So I think we are all set, and then you may start with your session. And these are the students. Hopefully, everybody is visible. Okay.
Fantastic. Shall I start sharing the screen?
Yes, ma'am. As you.
Perfect. Thank you.
Just 1 second, ma'am. Let us introduce you, student to about you. Let us give you your small, brief introduction, ma'am.
Ladies and gentlemen, esteemed dignitaries and valued participants, welcome to the next phase of our program. It's my pleasure to introduce Ms. Vaishnavi, who will lead our technical sessions with expertise. Let's make this a resounding success. Moving ahead towards technical session 1, we are blessed to have Advocate Dimitra Stefani join online to enrich our participants on introduction of space laws and principles of space law. It's my pleasure to introduce her. Advocate Dimitra is a part of International Institute of Air and Space Law of Leiden University and a faculty at International Space University. She focuses her research and teaching on space applications, cybersecurity, and privacy in space activities, and space resource governance. She is a board member at NBR Netherlands Space Society, executive assistant of International Institute of Space Law, advisory board member of Space Core Foundation, and member of European Center for Space Laws. Ma'am, we are pleased to welcome you at Modern Law College. I request you to enlighten our participants.
Thank you for the kind introduction and for having me. I hope I can provide you some useful background on the laws of outer space for your further discussion. I'm going to be sharing my screen, and I would just like to share that you see my PowerPoint here. Are you able to see my PowerPoint presentation?
Yes, ma'am.
Perfect. Thank you. It is a little difficult to see your side when I share my screen on Google Meet. So at any time you have a question you would like to intervene, please feel free. At the end of the presentation, I will stop sharing so we can see each other again. And we can have questions, but if there is anything pressing beforehand, please put it in the chat or once again feel free to intervene. What I would like to do in the next few minutes is provide a high-level overview, if you will, of a topic that is developing because we have many more space activities in the past few years, but also address some principles that were adopted already 3 decades ago. Space law is not a new thing. It's something that started being discussed already in the 40s when some scientists foresaw that we will have activities in outer space. And most of the space treaties were adopted between the 60s and the 70s. So we'll start with a brief history of how space law was adopted, and here I have put a picture that some of you may recognize. Unfortunately, with not so many diversity back then, things have changed a lot since the signing of the Outer Space Treaty in 1967. This is what you see here, and we see representatives from the USSR, UK and USA holding the credentials of the treaties and the depository of the treaties. This is the first international space law document. It is the Outer Space Treaty of 1967. It was followed by 4 more treaties ever since. Now we'll be speaking about them under the general framework of the UN Space Treaties. And if time permits, I have gathered also a few examples to see how these principles work in practice. Now to begin with, I told you already that around the 40s and the 50s, discussions have started around the development of a separate field of law. This is because we had the first space activities back then. We are talking about the peak of the Cold War, a geopolitical context that is a little different or sometimes similar to what we have nowadays around the world, but we had the 2 main powers of that time, the USSR and the US, competing each other on who would put space technology out there first. And it was the USSR that launched the first artificial satellite, Sputnik 1, in 1957. It was quickly followed by another milestone, the launch of the first human, Yuri Gagarin, in outer space. But it was the US that was the first to put the first human on the moon in 1969. All these factors led to states sitting around the same table and starting discussing a new field of law. They wanted to make sure that these activities that were able only for a very small handful of states back then could still be shared in terms of their benefits by other countries. They also wanted to put some rules for a new field of activity that is also a very risky domain. They wanted to ensure that countries could cooperate with each other in developing technology, and that perhaps a publicly dominated domain, usually with activities by governments, would also allow some private or other non-public activities to happen. But the number one reason that led countries not only to discuss but also to agree in developing space law is what I have highlighted, the need to maintain outer space for peaceful uses and to demilitarize it as much as possible. Once again, it is the peak of the Cold War, and they wanted to make sure that the hostile environment that was governing the relationship on the Earth would not spill over to outer space, perhaps with detrimental effects. This is a pattern, the peaceful use of outer space, that was really important in the development of space law, but it is becoming also important when we talk about space nowadays, because as you may have seen and may have heard from the geopolitical circumstances around the world, the issue of how we use outer space for armed conflicts or other issues between countries remains still important. The development of space law has progressed quite a bit ever since. In the last 4 or 5 decades, we have seen the space race between the US and the USSR transform to a race of technology between other countries. Usually we're talking about the competition between the US and China, but we're also seeing many more private activities, and sometimes we refer to the space race between, for example, Elon Musk and Jeff Bezos and their respective private companies. Nowadays, we are experiencing a completely different phase of space technology. We do not have any space race anymore. We're experiencing the era of space applications where we use space technology for scientific purposes such as navigation or meteorology, astronomy, but also for Earth observation, for observing different parts of the world from outer space, for telecommunications, for broadcasting, television signal, communication signal, internet to areas around the world. And as we're looking a little more into the future, what we're saying is that we may be able to leave the confines of the Earth's orbits, go further to the moon, to outer space, to other planets perhaps, send humans there, maybe use some of the resources that we find there, and maybe even further in the future send humans to space. And this changing landscape is also what is changing the regulation. We have, of course, a legal framework that was adopted many decades ago and is in force today. But as we're looking more into activities that are currently being developed and will happen in the future, we will see that some of these principles are challenged, and maybe we have to look into the existing principles either from a different perspective, with a different interpretation, or maybe supplement them with a few additional regulatory initiatives. This is how space law looks today. If we were to visualize it at the bottom, most of the principles come from the UN space treaties. We're talking about 5 treaties that were adopted by the UN Committee on the Peaceful Uses of Outer Space. It's a dedicated UN body that discusses matters of space. It has a scientific and technical subcommittee that meets once a year, and a legal and technical subcommittee that also meets once a year. This year is going to meet in the beginning of April in Vienna, where it is headquartered. And it is this committee that was discussing back in the days the adoption of the space treaties and is still discussing pertinent issues of spaceflight. In the middle of the pyramid, we see something that has been developed for the past couple of decades, a set of national and regional laws. Where I'm based in Europe, we have a set of European laws that govern the regional space cooperation around the member states, but there are several countries around the world that have adopted their own national laws. India is among them. The country does not have a very specific national space law, but it does have space legal documents to govern remote sensing activities in India. It has a very comprehensive space policy, and from what I hear soon, there's also going to be a national space law, which will be an important step forward, not only for the country, but also for the countries that cooperate with India. And if that does happen, please let me know, and maybe next time we meet and discuss, we're also going to be discussing about this. And at the top of the pyramid is something called soft law. It's a set of non-binding documents, such guidelines or other legal texts that have not been adopted as agreements or as treaties, but still govern some of the activities of states in the exploration and use of outer space. To give you an example, when we will talk later on about the mitigation guidelines, they do fall under this small part of the pyramid, what is called soft law. Remember the lower part of this pyramid, the UN space treaties, because this is how they look like. You will notice that all the treaties, of course, come with a very large title, but in short, we are talking about the Outer Space Treaty, adopted in 1967. To date, it is the most popular space treaty that has been signed and ratified by more than 100 countries. It includes general principles regarding the exploration and use of outer space by states and by extension also by private parties, and its provisions have been further specified in the three agreements: the Rescue and Return Agreement of 1968, the Liability Convention of 1972, and the Registration Convention of 1976. The Moon Agreement is the last one, the most recent. It is very similar in terms of content to the Outer Space Treaty, but it has been signed and ratified by a very small number of countries. And to give you hints, this may have to do with some of its provisions that have to do with the space research utilization. We're going to address this in more detail later on. But this is just to show you that we have two treaties, the Outer Space Treaty and the Moon Agreement, that have similar content. But when we apply them to their specific provisions, we may see that countries do not treat them the same, and their provisions may need further reflection. India is part of all treaties. When it comes to the Moon Agreement, it has only signed and not ratified it. And lately we also had a unique event in space law. We had the country withdrawing from the Moon Agreement. It was Saudi Arabia that, effective in January 2024, is no longer a member of the Moon Agreement. In the next two slides, I have gathered some of the provisions of the space treaties. I have also included an indication of where these provisions can be found in the text of the treaties, in case you would like to go back to them, read them, and further research on them. I will be sharing my slides with the organizers of this seminar, and they include in the notes some links for further reading. So if you would like to go back and look more into their provisions and maybe come up with your own topics, please feel free. The most important space law principle is that outer space is free. It is free for countries to use, explore, and scientifically investigate, and all areas of outer space should be free to access by all countries. This may sound like a rather generic principle, just establishing freedom that we all understand as a given, but it is very, very important because, first of all, it enables any country to go into outer space, and as long as it respects international law, perform its activities. But it is also very important because when we think of future activities, we have to make sure that this freedom is also preserved, and sometimes this is rather a challenge to support. Another very important principle is that countries should share the benefits they get from the exploration and use of outer space. This benefit should happen for all countries, irrespective of their degree of economical or social development, and outer space is a province of humankind. Again, in rather vague language, you will notice that in the space treaties sometimes they use very general terms and terms that are not specifically defined in their text. But it is another important principle to consider when we're thinking about activities, for example, such as space research utilization or large constellations, and how we can benefit from these activities and how we can carry out those activities in the interest of all countries. And to conclude the more general provisions of the space treaties, there is a clear prohibition as well, that is the prohibition to appropriate any area of outer space, whether this appropriation happens by means of sovereignty, by means of using an area, by means of occupying it, or by any other means. An important feature of outer space and something that distinguishes it from other areas of human activity is that it is outside the sovereignty of any country. Unlike, for example, the Earth, where we have certain territory of a country separated with a border from another country, in outer space we do not have such a concept. Whatever is in outer space is outside national sovereignty and is an area that does not belong to any country and cannot be appropriated. If we look into a few more specific provisions of the space treaties, and from now on I will be taking you to quite a few information so we'll understand if things become a little too much, but I hope that with some examples later on we can clarify a few of them. We have some provisions in the space treaties regarding the responsibility of states, liability of states, and their jurisdiction and control over registered objects via registration. Responsibility is a principle according to which states are internationally responsible for their national activities, whether these activities are carried out by governmental entities such as the Space Agency or not governmental entities such as private companies. States are responsible for those activities and they should make sure that they authorize them, for example, by giving a license and supervise them by conducting audits or by otherwise having an overview of those activities as they are taking place. This is an important provision because on that basis a lot of states have adopted national space laws to which I spoke earlier. Since they are responsible for these activities, they might as well lay down a few requirements according to which these activities should take place. On top of responsibility, states are also liable for their activities in outer space, and it is specifically the launching states that are liable. This is a very specific provision, that of the launching state. This is the state that launches, procures the launch, the state from whose territory or facility an object is launched. And it may sound like a complicated definition, but it reflects the fact that a space object may be procured in a certain country, maybe the research and development takes place in a certain country, but is launched by another country because only a handful of countries at the moment have space launch capabilities. So eventually the countries that do not have to cooperate with someone else in order to launch their objects. To give an example of India, for instance, there are launching capabilities, there is a spaceport, and there are several countries from around the world that will use the spaceport to launch their objects to outer space. I'm based in the Netherlands, and some of the private companies operating here, developing their objects, do use Indian rockets to launch their objects to outer space. In such a case, both states would be liable should the damage occur in outer space. This is a broader provision that more states are liable, and this is explained if you think of the very risky environment and the many threats for damage that exist in outer space. Speaking of damage, if this damage by a space object is caused on the Earth, then the liability of the launching state is absolute, and then there is no way of escaping a compensation for that damage. Whereas when activities happen in outer space and they cause damage there, the liability of the launching state is a fault-based liability. If fault can be proven, for example, by not following an international obligation to mitigate debris or an international obligation to not interfere with other activities, then this may lead to the liability of the launching state. This important distinction between absolute and fault liability is also justified by the fact that outer space is a risky environment. Once the liability regime should be rather broad, but at the same time, states should be encouraged to perform in outer space. Hence, if they cause damage there, fault should be proven as well. And to conclude the formality-related provisions, there are also principles about registering space objects, and this has been further developed in the treaty, the Registration Convention, according to which countries should share information about the activities that they're carrying out in outer space, specifically the objects that they have launched. Such as their composition, their purpose, the nature of the mission. And most countries keep this information in a national registry that they maintain for their own activities, but the UN also maintains an international registry, and I invite you to actually look at it later. If you Google UN Registry of Space Objects, you will come up with the result, because it is interesting to see throughout the years how many objects have been registered. I think you will find, last time I checked, I remember around 20,000 objects. And just to give you an example, those are not all the objects that have been launched, although there is no obligation to register space objects. Not all countries do register their objects, so we have many more than the declared ones in outer space. Why registration is important is because it gives jurisdiction and control to the country over its registered space objects. And although I said that outer space is an area outside the sovereignty of any country, this jurisdiction and control provision gives some power to a certain country, the country that registered the object, to exercise jurisdiction and control in that area. Moving on to a few, again, more general provisions, but referring to specific aspects of space activities, we have some principles regarding cooperation among states, the protection of the environment, and assistance to astronauts. As far as cooperation among states is concerned, it's very important to think about this provision because there are very few countries that can operate space activities by themselves. They will certainly need some sort of cooperation, technological or otherwise, with another country in order to be able to design and launch their mission. While they are cooperating, they should provide mutual assistance to each other and they should pay due regard to the corresponding interests of other states. This is further specified to the duty to consult other states prior to harmfully interfering with their activities. There are many activities that are happening in outer space. There is a chance that some of these activities end up interfering with objects in outer space or with activities that happen on the ground. And should that be the case, the country that carries out such an activity should consult with other countries whose activities may be interfered with in order to avoid and minimize impact. As far as environmental protection is concerned, there are provisions for the protection of both the outer space environment and the Earth environment. When it comes to outer space, countries should refrain from contaminating it, and when it comes to the environment of the Earth, the provisions are a little more specific. Countries should refrain from causing adverse changes to that environment. To give you a few examples, a contamination may be transporting a payload to the moon that carries on board a substance that is foreign to the lunar environment, releasing the substance and causing some sort of damage there. That is an activity that is not permitted under the space treaties. An example of adverse change to the environment of the Earth is something similar, what we call backward contamination, having an object returning to the Earth carrying material that is not familiar to the Earth and perhaps causing damage to the environment here. Another general provision is that of providing assistance to astronauts, which is reflected not only in the outer space treaty but also in a separate agreement, the rescue and return agreement. The outer space treaty speaks about astronauts as envoys of humankind. We're going to see later on when we discuss about human spaceflight what this may mean, because this sounds like a very novel definition, but we do not have this definition described in the space treaty. What does the envoy of humankind mean? But as far as the protection of astronauts is concerned, when they are in distress or in the case of emergency, countries that are in the vicinity in outer space or are otherwise able to provide their assistance should make sure that they do so. When astronauts or objects that are launched into outer space return to Earth and they do not fall as projected in the country that has launched them to outer space, the countries that find them should return them to that country. That sounds a little unusual, but most of the space objects and the astronauts that we launch into outer space usually return to the Earth with a vehicle or with a capsule that is falling into the atmosphere, and they do fall on international waters because it's much easier to return to the sea in case something is wrong, and of course we do not have any other facility around. But this may mean there can be a small miscalculation, something may not go as planned, and they may find themselves in another area of the sea or maybe on the territory of another country, and that country should make sure that the astronauts and the space object is returned to the country where it belongs. To conclude with the provisions as such of the space treaties, I would like to bring the discussion back to where we started, to the peaceful use of outer space and to the military uses of outer space, because those are also very important provisions of the space treaties. But as you may notice, they are not very clear provisions. The Outer Space Treaty is telling us that the Moon and other celestial bodies should be used exclusively for peaceful purposes, but it does not specify whether these peaceful purposes should extend to areas that are not the Moon or other celestial bodies, for example, the Earth's orbit or other areas in space that are not necessarily planets. There is some specification in the provisions regarding military uses of outer space. There are clear prohibitions of using nuclear weapons and weapons of mass destruction anywhere in outer space. But once again, something that is not very well defined is what a nuclear weapon and a weapon of mass destruction is. Because a nuclear-powered space object may or may not be considered a weapon, even though the intention is not to use it for malicious purposes. And of course, a weapon of mass destruction is prohibited, but a conventional weapon, if we read this text closely, does not fall under this prohibition. There are some other things that are not allowed in outer space, and this is to set up military installations and test weapons. However, if states need to use military personnel or equipment for peaceful or scientific investigation of outer space, they can do that. It sounds a little controversial, but when those treaties were adopted, and even in some cases nowadays, astronauts and outer space technology and equipment do fall under the military departments of several countries, and this is why military personnel and equipment that can be used for peaceful purposes in outer space are permitted. This concludes a very general overview of the content of the treaties, and in the next few slides I have chosen some examples of current space activities that can show how these provisions are applied in practice. One of the examples where we can see how these principles can be adapted to accommodate what is actually happening right now is that of space debris. Space debris is an object that is in outer space but no longer operates or functions. Maybe it reached the end of its lifetime, or maybe something went wrong and this object is not functional anymore. It is a very important issue. And this has led, of course, to an overpopulation of some orbits. This problem is accentuated by the fact that some of those objects are also non-maneuverable. We see that small satellites are being developed in masses lately, which is, of course, a very nice technological development. They are much more affordable. It's much easier for countries to launch them and operate them in outer space, and they do offer us important telecommunication and Earth observation services. But at the same time, they're very small. And once we put them into orbit, if something goes wrong, we cannot move them anymore. So having objects that cannot be controlled once they are in outer space, of course, adds to the problem of space debris. This is even more of a problem if we consider that those small satellites tend to be launched into totally different scales. They are not launched by tens or dozens. They are usually launched by hundreds and thousands. We have several large constellations that do contribute to the creation of debris in outer space. And we also have anti-satellite testing, ASAT, which refers to the technology that is used to destroy objects that are put in outer space. There have been some countries that have used this technology: the US, Russia, China, and most recently India, a few years ago, did use such a technology from the Earth to destroy one of their objects. It does not raise a very specific matter of space law, first of all, because this is an activity of a country against its own space object, so it does not trigger the provisions of international space law. However, it does contribute to the creation of debris. When India targeted one of its satellites, which broke down into several pieces, it had calculated that within 3 months, most of these debris pieces would fall back into the atmosphere. They would be dragged by the Earth's gravity, they would burn up there, and they would not leave any debris behind. It was a useful calculation to have, of course, before performing such an activity, but it was shown that it took a little longer. It took approximately 3 years for all those pieces to come back to the Earth's orbit and burn up there. This whole issue of overpopulating the orbits has led to a concept that is called the Kessler syndrome, and according to which, at some point, sooner or later, and according to scientists, it's sooner, much, much sooner than we thought, at some point, there will be a collision in outer space between two objects, which will cause debris, which in turn will collide with other functional objects, turning them into debris. And this effect will just cascade, rendering many objects around that area debris and rendering entire orbits around this area inoperable and unusable. This is what we are trying to avoid through debris mitigation and debris remediation methods. Debris mitigation refers to any methods that we use to not create future debris. And if you recall the space law pyramid that I showed earlier, there is a part on the top called soft law that is not necessarily binding. And this is an example of soft law regarding debris mitigation. There have been several guidelines. I have put some acronyms here. The UN has issued space debris mitigation guidelines, and the Interagency Debris Committee has also issued its guidelines. They include measures of designing, launching, and operating objects in a way that avoids the creation of debris. As I said, those documents are not binding per se, but when countries adopt their national laws and they issue permits for space activities, oftentimes they do include such guidelines under the requirements, rendering them mandatory. The Outer Space Treaty itself does not include a clear prohibition of creating debris, but if you think of the provision of not contaminating outer space and consulting with other countries before causing harmful interference, you will see that it at least provides for countries to notify each other before interfering in case they have a debris object, and countries to make sure that they do not burden the environment of outer space. When it comes to debris remediation, there we refer to technologies that are currently being developed in order to tackle the debris that is already there. Mitigation is about not creating debris in the future. Remediation is tackling the existing situation. This may sound like a very good technology because indeed it allows for space objects to be removed from an area where they may be a risk for damage to other countries. However, I would like to remind you of the provision regarding the registration of space objects and the jurisdiction and control of countries over the registered space objects, and point to a challenge that we may have there. Because, of course, a country may offer to remove an object that has been rendered a debris from an orbit, but it has to have the permission of the country that exercises jurisdiction and control over that object in order to be able to do that. So, of course, the technology exists, but it may raise a legal challenge. This technology is something that is currently being developed. It's still in experimental stage, but it is a very useful technology, and this legal challenge is certainly worth addressing. Some of the agencies and companies that are developing this technology are working toward setting up agreements with the countries that exercise jurisdiction and control over certain space objects in order to be able to lawfully remove them from the Earth's orbits. Another example is that of a human spaceflight, where the biggest challenge is the definition of an astronaut. It is not clear whether an astronaut refers to a trained part of a crew of an agency mission. Those are people that have spent considerable part of their lives trained to operate a spacecraft and also operate and conduct experiments in outer space. But we also see lately that there are people who are just able to afford a ticket to a space flight. We have people that have partaken to suborbital activities. Those are those planes that are being launched into a higher altitude that does not yet enter into orbit, but does offer gravity. I'm trying to find the correct terminology here, conditions of lowered gravity. So they are somewhere between the atmosphere and outer space. And of course, we have the umbrella term of a spaceflight participant that could cover all those people, whether they are in private or publicly funded missions, whether they're trained astronauts or just people who entered into a flight for recreation. It is important to define this term because it is the astronauts that, according to the treaties, have to be rendered all possible assistance. There are some thoughts that if they are not trained personnel of a spacecraft, then they do not deserve this kind of protection. But if we also look a little bit into the aviation regime and draw some similarities and differences, and certainly some lessons from there, we're going to see that safety of humans on board a spaceflight is very important, and it is better to adopt a broader definition of what is an astronaut, specifically to be able to provide broader assistance in case of distress. I will not go into the details of the differences and similarities between air and space when it comes to the protection of humans on board. For the sake of time, I just put it here for your reference. And I have included also some initiatives like the cooperation between between ICAO and UNUSA in defining safety for astronauts, but you can look back into the slides and further research if you would like. Another interesting recent development that has raised a number of legal challenges, many of which are not yet resolved, is the matter of space resource utilization. This is an issue that was raised around 2015 when a few private US companies started to discussing the business of space resource utilization. And because they wanted to have some legal certainty that these activities can be carried out in a lawful manner, they asked the US government to regulate these activities. And the US did indeed in 2015 adopt a Space Resource Exploration and Utilization Act as part of its Commercial Space Launch Competitiveness Act, which sparked international reaction. Some of this reaction was positive. A lot of this reaction was negative. It was negative, first of all, because it did not properly handle the issue of lack of appropriation in outer space. The question was, how could you allow the citizens of a country to appropriate resources if outer space cannot be appropriated by anyone? Another challenge sparked from this discussion was the issue of sharing of benefits. Countries have to share the benefits from their space activities. If it's only one country's citizens that are going to take part in those activities, how can benefits be shared? And a number of other issues that had to do with the general space law and policy aspects of space resource utilization. What was quickly realized, though, was that, first of all, space resource utilization as a business is not perhaps as profitable as we imagined, because those very companies that initiated the discussion quickly went bankrupt. It is a business reality, it can happen, but it also shows that as a market is not that profitable. And if someone would think that the sharing of benefits would mean the sharing of trillions that would be made out of space resources, maybe that's not the reality yet. Another important realization that came, though, is that space resource utilization may be a business activity, but is certainly a very important component of space exploration. So the discussion quickly changed, and countries realized that outside any business and commercial activities, using resources in outer space is essential for current and future space missions. Because if you go to the moon, and you are able to find some fuel there by using some of the resources, most likely water, to power either your return to Earth or your trip further to outer space. This will save a lot of other resources because objects will not have to carry all the fuel they need for their entire trip. Even here on the Earth, when you would like to take a very long road trip, of course, you stop at some gas stations along the way and you don't have to carry your entire fuel with you from the very beginning. This is a very important component for space exploration, and this is what shifted also the discussion on the legal aspects of space resource utilization. Countries started started trying to find a few solutions in order, of course, to uphold the provisions of the treaties, but also be able to carry out those activities. One solution that was found for the issue of appropriation, for example, and this is a matter because not only resources will be appropriated, of course, if you invest capital and technology to go to space and extract resources, you will want some rights over those resources, but also because some of those activities may also require some priority rights. Having the certainty that if you're calculating a mission for a few years in advance, there will be no other company or a group of states going to perform in the same area. However, this may be a little challenging if we consider the non-appropriation principle, and the solution that was offered for that is to consider resources as not part of outer space anymore once they are extracted. And because they're not part of a celestial body, they are not appropriated anymore, so they do not fall, they can be appropriated, so they do not fall under this prohibition. And as far as priority rights are concerned, without appropriating outer space and without limiting the freedom of access to all areas of outer space, some priority rights can be given if they are for a certain area, for a certain time, and for a certain type of activity. The sharing of benefits is an issue that is still being discussed. As I mentioned, monetary benefits may not be the number one benefits that we can get out of space resources at the moment, but technological and scientific benefits definitely belong under this category, and many countries and many private companies are working toward sharing the benefits this way. Other provisions that are not very clearly connected to the matter from the beginning are, of course, the provisions that have to do with the protection of the environment, of the Earth, and of outer space from such activities, but also the provisions that call for avoiding harmful interference with other activities. And of course, if we have more operators performing in outer space, most likely on the moon, we will have to think about those provisions. In the beginning, I mentioned that the Moon Agreement does not enjoy the same number of countries as the other space treaties. And one of the reasons for that may be the provisions it has regarding space resource utilization. The Outer Space Treaty does not speak about space resources, it only speaks about the prohibition of appropriation and the sharing of benefits. But the Moon Agreement speaks specifically about space resources, and it says that the moon and other celestial bodies, their surface, subsurface, and any part thereof cannot be appropriated. So the solution that I offered you about resources and appropriation does not work if we consider the Moon Agreement. And this is what has prompted countries to refrain from ratifying the Moon Agreement. However, this does not mean that it does not allow such activities, because the Moon Agreement says that when space resource utilization becomes feasible, then an international framework should be in place. And at the moment, we may be close to that international framework, or at least we have initiated the discussions. So in any case, the provisions of the Moon Agreement may be complied with. India is one of the major spacefaring nations that has signed the Moon Agreement. It has not ratified it, but the rest of the countries, around 12 countries that have signed and or ratified it, are not major spacefaring countries. There are, alongside the US law that I mentioned, several other developments around the world of countries that have adopted their own national laws on space resources. Luxembourg followed shortly after, and most recently, the UAE and Japan with their own space resources acts. On the international scene, as I mentioned, there are some discussions about establishing an international framework on space resources. This has been the working material of the UN Committee on the Peaceful Uses of Outer Space, which established a working group specifically on that matter. This working group is still carrying out its activities. It has a mandate of another, I believe, 4 years, so maybe by then we will have some sort of development. But in the meantime, we also see cooperations among countries. They do not amount to an international framework, but could be considered as such. You may have heard of the Artemis Accords. This is a US-led initiative for lunar and further space exploration. So far, 35 countries have signed the Artemis Accords. I am not aware whether India is part of the Artemis Accords. I want to check it this morning, but then I forgot. Maybe you can check it as I'm mentioning that. Another similar cooperation is the International Lunar Research Station, ILRS, which is an initiative between Russia and China, and a handful of other countries have also subscribed to that, and we likely cooperate with Russia and China in this regard. So a lot of things are still happening. Many issues still left to be resolved, but one important learning outcome from space resource utilization in its legal aspects is that when we want to enable an activity, there are ways to interpret the legal framework in order to do so. Let me finish with an interesting example. Interesting depending on when you discuss it and what sort of developments are happening around that time. Every so often, the military uses of outer space become a little bit redundant because we tend to see that countries cooperate much more than they actually compete. However, this depends very much on the geopolitical circumstances around the world on the Earth that eventually have an effect in outer space. As I mentioned, there are certain things that are prohibited in outer space, but because those things are rather specific, the things that are not defined as such, as weapons of mass destruction or nuclear weapons and so on, fall under the gray area of things that are permitted unless otherwise indicated. There are several countries around the world that have a space force or a space command. This is, of course, a permitted activity, and this is because most of these departments are working toward defense capabilities, not offense capabilities, so they are not seen as against the peaceful uses of outer space, but also eventually because those space forces and commands were existing. Most militaries, if not all militaries around the world, have space capabilities. Those just happen to develop into separate departments. We also have NATO that recognized a couple of years ago space as an operational domain, which means that the provisions of the North Atlantic Treaty are also applicable to outer space. For those countries that are members to NATO, this means that if one of their space objects is hit, for example, the principle that says that the rest of the NATO allies will cooperate with that country to counteract to this threat will be in place. There are also some other technologies that are of military nature but are used more and more for non-military purposes as well, is what I mentioned here with the acronyms Space Situational Awareness and Space Traffic Management. Those technologies enable us to see which objects are where in outer space. They are very important, they are essential technologies to make sure that collisions are avoided between debris or between functional objects. However, a lot of these technologies are still developed within the military confines of some countries. Hence, they cannot be shared further with other countries that may not have those same capabilities. And increasingly so, a lot of countries view space assets as part of their critical infrastructure, which means that they take measures in order to protect these assets accordingly. There are several ways in which we can use outer space for military purposes. There are several spy satellites. Besides, military space technology was primarily developed in order to be used for military purposes. So spy and reconnaissance satellites were among the first objects that were launched into outer space. I mentioned the anti-satellite testing technologies. They are seen as military uses because, of course, if a country can target one of its own objects, it can target the objects of other countries as well. There may be conventional weapons that are carried on board satellites, but the most common threat, sometimes for military uses or other malicious purposes, are cyber operations against satellites, either interference or jamming or spoofing of the signal of satellites. On top of the provisions of the space treaties that are not always very clear when it comes to what is permitted and what is prohibited, we do have very clear provisions that come from the UN Charter. I'm sure you're familiar with them. I will not go into detail, but we do have a prohibition, if you will, of use of force or threatening to use force, but also provisions that enable countries to defend themselves if they are attacked. And those are provisions that can be used also within the context of space activities. This is not the entire picture of space law. I have gathered the most important provisions of the international space treaties. There is a number of documents, of space law documents or national, regional, and international level. I'm only mentioning them here for the purpose of completeness. You can go back and look into them. You will see that most of them are not binding, for example, but they do regulate important activities such as remote sensing or debris mitigation. But I would like to conclude and maybe leave some time for discussion with just a couple of messages that, of course, the international treaties do not regulate in detail. They only include general principles. This creates some challenges because we miss some definitions, but at the same time, it allows us to interpret these principles according to the current technological developments. We also see that a lot of these principles are challenged because of these developments, and especially because more commercial and more private actors are involved in space activities. A lot of these issues, as we're waiting perhaps for new international regulations, are arranged nationally by countries that adopt their own national laws. And of course, a message that, as you have seen, the law is rather limiting, as it always is, but those rules are there for a reason. And the reason is that we have to maintain outer space as sustainable as possible in order to be able to show its benefits now, but also into the future. There are many other fields that are also attached to space law, fields that govern space activity in particular. Those are much more detailed. I do not examine them here, but just to give you a few ideas, there are intellectual property connections when it comes to technology that is developed around the creation and launch of space objects. There are also privacy concerns when it comes to the collection of Earth observation images, and of course, a lot of export controls when it comes to sharing sensitive technology with other countries. With that, I would like to conclude. Thank you very much for your attention. And if you have any questions, I will stop sharing my screen if I manage that and be able to see you and perhaps hear some of your questions. Mhm, mhm. Thank you very much for the question. So, indeed, there is no sovereignty in outer space, but there is a provision that says that the launching state is liable for the damage. If I understood the question well, you're asking which state is liable for a space object. Is that correct? Mhm, 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 mhm. Yeah. Yeah. It will be the launching state or launching states that are liable. Even after they launch it, the liability stays with them for as long as the object is in outer space. So until this object ceases to exist, for example, but by being destroyed or most likely by being pulled into the Earth's atmosphere and burning up there, the launching state is going to be liable throughout. If there are more than one launching stage, which is very often the case, there may be a country that procured the launching because it researched and manufactured parts of the space object. There may be a country that launches the object because it provides the rocket, for example. And there may be a country from whose facility, from whose spaceport the object is launched. All those three countries are going to be liable. If a state suffers damage, it can go against any of those three states that are going to be liable in full. And states, when they cooperate in launching, so when we have more than one launching states, have agreements among them in order to arrange liability. So if someone comes after them, they will have, of course, to provide compensation, but with agreements among the launching states, they arrange who is going to pay and how and for what. That question was not very clear. If you could please repeat, or someone who is closer. Mhm, mhm. Yeah. Thank you very much for repeating, and very interesting question. This is of course an informed speculation because countries have not expressed specifically why they have not signed or ratified the Moon Agreement. But if you compare the Outer Space Treaty and the Moon Agreement, you will see that most of their provisions are similar. The provisions that are not similar are the provisions that refer to space resource utilization. There we see that the Outer Space Treaty does not contain such provisions. It only includes the prohibition of appropriation of outer space. But the Moon Agreement is very specific. It prohibits the appropriation of any area of the moon and celestial bodies, including its resources. I did not go very much into detail there, but let me take this opportunity and maybe explain it a little further. It also mentions that of the moon and other celestial bodies that says that should space resource utilization become feasible, there should be an international framework. All these provisions are not prohibitive when it comes to space resource utilization, but they are more limiting compared to the other space treaties. They do ask countries to establish a framework. They do ask countries to not appropriate space resources. And this may have been the reason that countries chose not to sign and ratify the Moon Agreement, but to opt just for signing and ratifying the Outer Space Treaty instead. Mhm, 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 mhm. Yeah. That is a very interesting question. Thank you very much. So, insurance is something I did not address here because it's a more specific, more detailed matter. Insurance is part of the licensing requirements of activities. So, it really depends what each country includes as licensing requirements. Some countries require insurance for the launch and for the operation of the object. Some countries require insurance only for the launch or only of the operation. Some countries do not require insurance. This is also what makes a difference to a company when they are thinking where to establish their activities to maybe choose something that is more convenient for their activities. Most of the active countries do require insurance, at least for the launch, because it's a very risky activity. And if things are going to go wrong, most likely are going to go wrong during the launch phase. But there may be other countries that do include also insurance for the operation phase. If something goes wrong and there is insurance, the process will be the following. If the countries bring up the liability convention, the state that suffered the damage is going to go against the launching states. The launching states are going to have to pay anyway. What the launching states are going to do is go back to the operator whose object caused the damage and ask, of course, for recourse for some compensation. And this is where insurance comes in, providing some of the compensation. It really depends not only on the national requirements, but also on the amount. Some jurisdictions ask insurance for a rather large amount of money. And there, if you're a private operator, you will have to prove that you are credible enough to get this insurance. The insurance discussion is a very, very interesting one. And it's also something that is offering, if I can explain it this way, a competitive advantage. We have certain companies that have developed the expertise, that have the capabilities, that have the track record to be able to seek adequate insurance. But there may be smaller providers or there may be operators that develop a novel activity. A lot of the cybersecurity related systems are currently unable to be insured because it's difficult to explain to an insurance company what the risk is for them to be able to offer you a premium. So that really depends, but it was a very interesting question. In short, it depends on the licensing requirements. If a damage is caused, the insurance is going to take up some of the amount. The rest of the amount that is not covered is going to be paid by the launching state. Okay. Thank you very much, and feel free to reach out for any other question. Have a good day. Bye-bye.
on various aspects of air and space law in various premier institutions, including Indian Space Research Organization and National Defence College. Sir, we are pleased to welcome you at Modern Law College. I request you to enlighten our participants.
Take your time.
So we have connected your. It is touch screen, right? Yes.
We know and
Yes.
Can we
Sir,
have a look?
you want to take the lecture stand or?
I think I can speak from here,
Okay, sir.
if that is fine.
Yes. Yes, sir.
Yeah.
Change the slide for the नीचे को slide छोड़ दो। अरे वो तो देख लेंगे। Listen. Yes, sir.
Can we have the slide changer?
Is there a like slide change? Slide change. Sir, के लिए वो slide change है. Slide change कर. Sir, you might have to do it from here.
That's okay.
You check for anything else, sir?
Nothing. So it has to be done from here?
Here or you can use them.
Yeah. Okay, done. It's working.
Okay. Okay, sir.
Will mic be required?
If you need, we have this one. Switch it on. Guys, please maintain silence and there should be no more commotion. Just stay on your seats. Okay? Yes, sir. Sir.
Will it work?
It's connected, right?
Not yet.
नहीं जरूरत नहीं पर PPT में right के लिए this slide share and this is for front
That I'm working.
this is for point
Yeah.
you don't
दिख रहा है क्या?
सर दिख रहे
हाँ, ठीक है. Let check. वो I think
Perfect.
Done? Yeah. Okay, thank you.
Very good morning, everyone. It's a pleasure to be with you. And before I begin my presentation, I express my gratitude to the Modern Law College for giving me this opportunity to interact on something which is, as rightly pointed out in the inauguration, very modern. And so we cannot have a better place than Modern Law College to talk about it today. I am told that not everyone is conversant with this field of law. So therefore, through this presentation, I have changed the presentation scheme in order to make it more meaningful to the audience and maybe talk about things which are related and maybe not take it to the details, but then try and maintain a balance in all the considerations. And I miss my other two colleagues who could not join. So let's begin our discussion. Second, feel free to speak to me in between You don't need to wait all the way to ask your questions. So let's talk. And when we talk, the first thing that comes to my mind is, when you think space, what comes to your mind? Yeah.
Asteroid mining.
Straight away.
Yeah.
Asteroid mining comes to your mind. Okay. Different minds, different things. Anyone else?
Something which is not occupied.
Something which is very spacious.
Astronauts and Kalpana Chawla.
Kalpana Chawla comes to your mind. Different minds.
Infinity.
Infinity, vastness, and
Cosmic connections.
cosmic connections. Well taken. And
UFOs.
celestial bodies,
UFOs.
aliens.
Zero gravity.
Zero gravity and the excitement about it and the risks associated about it. And
Possibility of multiple universes.
possibility of multiple universe. Okay, and
Voidness.
whiteness. Of course. It's so black out there. Anything else? Black hole comes to your mind. Yes, we got fantastic picture of black hole a few years back, proving our theory. We could see it for the first time through our eyes, not our eyes though.
Intangible.
Yes, something that is intangible, something that is beyond comprehension. You must have seen those situations where mass can be converted into energy and can be transported, Star Trek and all that, right? What else comes to your mind?
What the brain fails to think further.
Pardon?
What the brain fails to think
What the brain fails to think
further.
further. Yes. So if I keep on adding, the session will end with this end and end. So I end that end that I have been asking you and trying to engage you with. I will have an opportunity in this presentation to take you to some aspects of this and maybe a little more. Please appreciate that when we talk about the space, we are constantly challenged in terms of our understanding. The more we explore it, the more we realize we don't know it. We have competing theories, further competing theories, one theory challenging the other, and our existence is part of this universe. Nobody asked me this, I was looking for this, I do it. How we came into existence, how humanity came into existence, to what we owe our origin to, sun and all these bodies, how they originated, how galaxies originated, competing theories, different ages, relying on different theories. They rely on the theory that those are prevalent today, but theories apart. I again emphasize that the more we learn about it, we realize that how less we know about it. With this introductory remark, I have said presentation's name I have changed. This is a photo, and it says that photo says so many things. What it tells you. Have you seen this before, anyone? Raise your hand. Very good. I'll come to you a little later. Yeah. Any speculation with regard to what this is? No, wait, hold on. Those who know must wait for those who are yet to know and will soon know. Okay, those who know.
I think it's the Earth's perspective, like outer space's perspective of Earth.
Outer space perspective of Earth. You are sounding it so technical. Can't we simplify it?
That white dot is Earth.
That white dot is Earth.
The pale blue dot is the Earth. It is the Voyager 1 leaving the our solar system.
Yeah.
When he was leaving the solar system, so NASA turned it for one last time
Right.
before it went into the
You're
void.
right. After this session, or maybe when you get time, search for this on Google, the pale blue dot. right? This is the pale blue dot. 1977, NASA launched a very interesting mission, Voyager. And thereafter, they launched another mission, Voyager 2. What was the objective of launching them? Any guesses? We keep launching so many things. This could be launched here, Voyager. Yeah.
It moves endlessly into space.
Go on, go on, go on, go on, go on. It has, every machine has a time line. Before that, after that, possibility is, or projections are that it will malfunction. But then this has stood test of time and test of universe as well. So it went on past Saturn, past many other planets, and then moved, crossed the solar system, moved into the interstellar. Interstellar reminds you anything? The movie, right? So, what's some interesting movies and documentaries if you want to understand space and how we are trying to comprehend and get to terms with it? Some very realistic, very interesting research being undertaken to come out with those movies. I would suggest look for 4 or 5 good movies. I think we also had in Bollywood one very interesting movie a few years back. Now, of course, PK had a connection. The fellow coming from somewhere, trying to adjust to what we keep on doing here. Mission Mars, the recent one. I do expect some Mission Chandrayaan also soon, coming from Bollywood, though I do not know. So coming back to the Voyager, yeah, just prepare a list and you can watch. That's my suggestion. You must watch. So this is, so Voyager was moving across Saturn. It was about to cross the solar system. Just think of what I'm talking. If I was about to cross the solar system, there was one suggestion by Carl Sagan. Read his book, available easily. He said it has given us so many fantastic close pictures of the things that we otherwise don't see. And why don't you think of turning the cameras back, as rightly pointed out, and see how we look from there. Yeah? This was not agreed initially, but then agreed, and ultimately when the cameras were turned back, this was what was visible. Just to be a little more precise, the distance that we are talking here is 6 billion kilometers. I see people taking photo, adjusting focus. This is space. 6 billion kilometers, and this was undertaken on 14 February 1990, right? And it says everything that we were trying to tell. It challenges the anthropocentric conception of life itself. We feel we are in the center of the universe. Are we in the center? Am I visible? I was there. No, I was there. I'm talking about myself. I was there. I can't see myself. Can I see any of the places? No. Can I see the earth? Read about this photograph. It's just, we are just a pale blue dot. Nothing more. So those who think everything is for us, that's the truth. You are a part of the universe. Universe is not because of you. Universe is very vast. And anything else that comes now that I have told you few specifications about the picture, what comes to your mind? Over and above what I have said. Life is a lot about imagination and spontaneity. What comes to your mind, apart from whatever I have said?
A lot of unexplored area.
A lot of unexplored area. Anything else?
We are not alone.
We are not alone. Who can you see here? We are not alone, but in this figure though we are alone.
Yeah.
It's so isolated and it's so lonely. And I mean, think.
The sky is not the limit.
Yes, it wasn't. It has never been. It used to be said earlier. Sky is the final frontier, sky is the limit. But people realize it is not. That's why we have been moving. it's so lonely, and this is the only place that belongs to you. Read what Carl Sagan wrote in order to contextualize. It's available on YouTube also. Watch this video. What he said. Beautiful. This is the only place we have. And madam, nowhere to go. Perfect argument for protecting the environment and protecting the earth. Because that's where we belong to. And I'm not saying that. Carl Sagan has already said. It's just that you haven't read. I have read a little bit, and so therefore I'm helping you read what he said about this. So, Voyager, where is Voyager now? It is still traveling. Interstellar, solar system crossed, everything crossed. We have had problems in that. I think I was, when I landed yesterday at the airport, waiting for my young colleague to join me. I was reading, there was some problem that they are facing now. It is far beyond its expiry. It has worked fantastically well. Voyager 2 is also joining from behind. And this is a place where we just don't know what it is. And so therefore, whatever is our opportunity, or opportunities like this. Apart from the photos that you take, you might be aware James Webb Telescope that we have put in place. Some scintillating fantastic pictures of what that telescope is seeing. Go to NASA's website, watch those pictures, and enjoy what we are part of. Who went to moon first? I need not to ask. Right? Everybody knows. After reaching there, what he said, this was what was said, nothing new, everybody knows. First step for mankind. Giant leap for mankind. Then they also carried this insignia where they said, we come in peace for all mankind. So astronauts, as Dimitra was pointing out, they are envoys of mankind. Okay, so an astronaut goes to space, Kalpana Chawla was not representing any particular country, they were representing the whole humanity. That's the conception, and therefore everyone should try to help the astronauts if the help is needed. How many people have gone to moon till date? No, I'm not asking whether you have gone. I'm asking total how many have gone. Total. We have number of missions there as part of Apollo program. So 12, just check out the figures if I am wrong. 12, 6 missions. The last one carried this message: we shall return with peace and hope for all mankind. Next session, my very young and promising colleague Aditya is going to speak about, he said, weaponization and militarization, and look at what we are talking, right? But then I leave it for him, and he will do it fantastically well. I know him for being very impressive. Exploration of art, excitement of art. Let's talk about some business as well. So we are here talking about global space economy. As we have aviation industry, we have space industry. But what exactly it is? So it covers all activities and use of resources, create value and benefits to human beings in the course of exploring, researching, understanding, managing, and utilizing space. Are you getting this? Right. And all this will include space commercialization. Okay. Then emergence of private players. Just spoke about it. Any players that you are aware of? I said any company. She said Elon Musk. You are right. I have no problem. I don't believe this. Right? Sometimes individuals are known more than Virgin Galactic, Blue Origin, many more than just an example only. Space commercialization. So, a greater part of our journey through space has been space for Earth. What do we do in space for Earth? We go to space and use the space for Earth. How do we use? Satellites, remote sensing, space for Earth, right? And then more. My another friend Chinmoy is going to talk about small satellite constellations. You will get your opportunity to know more about it. So therefore, all these activities are space for Earth, right? And then there is another. As we have developed technology, what has happened is space for space. हमको वापस नहीं आना है. If you understand Hindi, we are going to go and be there. And when we will be there, what we will do? Huh? Signal negative although there are projections, but why to start? This is the first question I asked with regard to this. Space में जाएंगे, वापस नहीं आएंगे, वहाँ क्या करेंगे? Colonize करेंगे. We can be a little more positive, although you are right. Yes.
Exploration.
Exploration. Exploration करते हैं.
Longevity, human longevity, life will be rejected.
Life will increase. Okay. Anyone else?
Like a home away from.
Home away from home. Right? अगर कहीं ऐसा हुआ कि अर्थ अनफिट हो गई तो वहां चले जाएंगे, राइट? और वहां जाने के लिए हमें वहां कंस्ट्रक्शन करना होगा. ऐसा तो नहीं है कि कंस्ट्रक्शन को वापस लाएंगे. तो स्पेस फॉर अर्थ नहीं है, स्पेस फॉर स्पेस. We are going to go there, right? So when we went to moon, Neil Armstrong, exploration. Now we are focusing again on going to moon, and this time around what we are planning for is we are going to make moon a gateway for further deep exploration of space. If we want to send manned mission to Mars, it's very difficult from Earth directly. So from Earth से space पे जाएंगे. We'll go to moon. Moon we will have our installations in place, and then another launch from moon all the way to. Are you understanding? This is not space for Earth. This is space for space. Since you are telling me space for Earth, I'll move on. Indian space industry, where do we figure? Global space industry, Indian space industry. Big size. We are 2% of this economy. Now you understand how we have to cover a distance, and government is very keen that they will. And therefore they are undertaking a lot of initiatives, right? And this is how you should be also, because space is not only about showing your muscle, it is as much about showing your economic muscle as well. So therefore, 2% is what we have. For our players, now these names I do not know, people know Elon Musk. These are also very relevant players. These are commercial arms of ISRO. So Antrix Corporation and New Space India Limited. All the commercial launches, plans are that they should expertise and do. Then Chandrayaan is in news. Mangalyaan was referred. But then the first traces of water on moon were discovered by Chandrayaan. I'm not speaking about Mangalyaan, I'm not speaking about brother Chandrayaan, you know it, it's comparatively recent, but the evidence of water on moon to the world was given by our first mission of Chandrayaan. That's our contribution. We have been contributing to space for peaceful purposes right from day one, since we launched, because we have been utilizing it for education. Have you watched that movie, Rocket Boys? No, it's not a movie, it's a series. If you haven't seen, you have missed something. Of course, I'm not their representative, I'm not selling the movie. Yeah. Outer space treaty. Even I was talking about it, whosoever goes to space, they are not to do national appropriation there. So a friend who spoke about colonization, no, right? Appropriation nahi karenge, because space is the province of all mankind. Envoys are representatives of all mankind. So therefore, something which belongs to all mankind belongs to everyone, right? So therefore, no appropriation. Whatever you are doing, do it for the human civilization as a whole. If you look at Article 1, see this. You explore, you use outer space, but the purpose is for the benefit and interest of all countries, because we realize that all countries cannot go there. Very few have the capacities, technical capacities and economic capacity. So therefore, what about those? Will you benefit them? Look how much of forecasting is done through space technologies in the present time. There's tsunami warning, earthquake warning, तो मुश्किल है. But then, huge contribution. And space technologies are making your life better. I'll give you a very instant example. If all the satellites get damaged, God forbid, if it happens, what will be the consequence on you right now? This will take away smartness from your smartphone. And if the smartness of your smartphone is taken, part of your smartphone is also taken. Trust me. You just think of what I have just said and you will realize how true it is. Right? See this. The whole space is free for exploration. Anyone who can go, right? Anywhere you can go, provided you have the capacity. Anyone means states. In accordance with international law, how many of you have done international law till now? Raise your hand. Just raise your hand. I don't ask any question. Promises. I promise. Okay. Okay. So therefore, international law. Everything has to be done in accordance with international law. That's the significance of international law. And all areas should be freely accessible. Okay? Moving further, see this freedom of scientific investigations. Scientists will go and they do go. They are part of the mission, grand missions. Facilitate and encourage international cooperation. So we are going there in cooperative spirit. Okay? This was all in 1967 when we entered into this arrangement. Then somebody was talking about moon agreements. I'll talk a little more specifically. See this, common heritage of mankind. OST said province of mankind. Moon said common heritage. What's the difference with that? Common heritage of mankind and province of mankind. Province is like ownership. Okay. Okay, which one out of these two you connect very spontaneously? That was one of the reasons why not many countries signed. Because it's not common heritage, people were not interested. People think states, all the efforts we make, all the money we incur, and then for what? For common heritage of everyone. Little problem there, right? How do we sustain ourselves, right? So therefore, this is one very important thing. Okay. Moon is not subject to national appropriation. OST said nothing is subject to national appropriation. There is moon agreement, so moon agreement will definitely say moon is not subject to national appropriation. Moving further, all these are reasons why major spacefaring nations decided not to sign it. Neither the surface nor the subsurface or natural resources in place shall become property. No property rights on state, international, intergovernmental, non-governmental organization, national organization, non-governmental entity, and of any natural person. Who comes to your mind?
All these people who bought a piece of land.
Comes to your mind. Different minds, different people. Elon Musk comes to anybody's mind. He's watching. He has read all this, and then yet he's doing what he's doing. Good. No, I said good. Placement of personnel, space vehicles, equipment, facilities, stations, installations. We were writing it in 70s. And look how realistic. We felt we are very soon going to inhabit moon through our advances. Today we realize that no, it's not that exciting. On or below the surface and not create a right of ownership over the surface or subsurface. We will do everything, but then no ownership. Moving further, right exploration and use without discrimination on the basis of equality in accordance with international law. By now, I think it should not be difficult, so I'm not coming in here. We undertake to establish an international regime. So we felt that it's going to be very close now. So therefore, international regime let's have in place. Did we do it? We didn't do it. Right? And then inform the Secretary General of your activities. Public also, international scientific community, to the greater extent, any natural resources that you may discover. So if you find something there, kindly share with everyone. Right? That's the idea. 11.7. What is the main purpose of the international regime that I have just referred to? The purpose is see orderly and safe development of natural resources. We are close, and therefore orderly and safe development of natural resources. Then rational management of those resources. We felt we are definitely going to get it, but technology is not that advanced, so therefore it could not be carried on further. Expansion of opportunities of the use of resources and equitable sharing in the benefits derived, interest and needs of developing countries. Right? Developing countries should also get something out of what few states were doing. So therefore, a very interesting regime was sought to be established in Moon agriculture. Of course, we could not go further because if the spacefaring nations won't join, then who will carry it forward? Essentially, these are obligations for the then spacefaring nations. Now, domestic regulation. I am coming more closer to older times when I am talking. It so happened that उसके बाद last mission to the moon, there was no further mission, nobody went, nothing happened. And then suddenly people became interested. Again, as technology developed, it makes you think very realistically about your capacities. So therefore, nations started coming out with domestic legislation. Okay? In between this phase, so I'm talking about 2015, United States took the lead, came out with it, domestic legislation. Between Moon Agreement and US domestic law, there were a number of declarations and resolutions which UN came out with, and those who are students of international law, they understand very well what is the difference between treaty, convention, and resolutions and declarations. Right? Without saying anything much of that, let's look at it. So USA came out with a law. They have been taking very interesting position. They said appropriation क्या है? Appropriation extraction नहीं है. So long as we are not extracting anything from the celestial body, it's covered. But the moment we extract it and take it out of it, then there is no appropriation. And if there is no appropriation, then whatever you have not allowed, because you call it appropriation, will have to be allowed. And what will be allowed? ये मेरा है, ये भी मेरा है, ये भी मेरा है, वो सब आपका है जो आप accept कर सकते हैं. And this is the shift in space law. Big shift. And the shift is not happening multilaterally. The shift is happening domestically. Your country, your law, you can make any law. But then, if you do it alone, people will ask you, what are you doing? You are an exception, this is not the trend. So therefore, there were others watching. UAE said, we will also come out with the law. Right? Luxembourg. Very interesting country. They give a lot of relaxation in tax and fee for space activities. So companies are always interested to go there and then operate from there. Right? Because of the concessions. So therefore, Luxembourg also came out with the law. Okay? And then Japan, the latest edition. Remember, I spoke about all this in the last part in the name of recent developments. The problem with domestic legislation is what? Some country will say something, some country will say something, some country will say something. There will be no uniformity. So, definition of what is a space resource varies. Right? What is the variation? Some people say biotic, abiotic, process for whatever we can extract. Somebody was talking about we are so lonely. Somebody was talking about we finding someone. So biotic no way. And if you cover abiotic and biotic both, what remains in space? unless we find something later on, which is not falling in any of these categories. But then the idea is that you will cover, if you go on for an interpretation of it, the possibility is that you will cover everything, right? So therefore, this is a very concerning development in the field of space. Now, through domestic efforts, nations came out with a law and started making claims for property rights. The primary objective of these legislation was to encourage private players. Because it was becoming difficult for the states, and states realized it's not possible that we go on making so much of investment in space exploration and all kind of things. So therefore, let the private players join us, right? So you will talk of space startups. The purpose of US was 2015, private players should be encouraged to invest more and more. And it has worked. But then in order to encourage private investors, they would obviously ask for returns. And what returns they will ask for? In the form of what we get out of this. So therefore, as a consequence, you will have to recognize what otherwise was very difficult to recognize. So therefore, a change in approach. Where do we figure in this? So India also came out with a legislation, but then the bill had to be withdrawn. A lot of suggestions were given, and I understand the government is working on it. But then the approach taken is the same. Okay, licensing regime is there. So variations are 10 license we transfer. You go to the extent of also acknowledging the license can be transferred. India, the purpose behind the legislation was the same only as the case with any other country, encourage private players. Since we are just 2%, therefore there is only one way forward, and the forward is to encourage private investors to come in, invest, and then let the economy grow, let the space industry grow. Germany, Russia, and Brazil, these come up as counter argument. No, this is not done, this is wrong, and all that. So, at present, the situation is that we have both kind of views, right? This is where we stand. But then, because of the domestic legislations, nations have moved ahead. Okay? Moving further, Artemis Accord, there was a reference to this as well. US has gone far ahead with this. So they came out in 2015 with the legislation. Then Artemis Accord. What is this accord all about? They say it's a political statement in compliance with the international law obligations. And then the nations have to enter into bilateral arrangements with US. It's a US-led initiative. Okay? And what they are going to do? I said I'll come back to moon, I'll come back to moon. Moon is the gateway for further exploration, and whatever we are going to do in space to space, or space for space. So big developments. 35 countries have joined. India has also, right? This you can read bilateral mechanism. On 4 December 2023, we have 35, and the number is swelling. The number is expected to swell this week US led. However, there is another movement to this International Lunar Research Station. This comes, any guesses on whom? Some nations felt Artemis is too US-centric. Right? They have also made it very accommodative. Right? So look at this. International partners are welcome to participate in the demonstration and construction of the International Lunar Research Station at all stages of the project and at all levels of the project. Purpose वही है. So look how we are moving ahead. Get a sense of direction. If you get a sense of direction, my purpose is served. We welcome all countries to join hands in the International Lunar Research Station. Some 17 countries have joined. Just look at the list. Azerbaijan, Russia was part in the undertaking as well, UAE, and there were a number of other nations. These kind of projects are not new, being led by China. So therefore, have a good context of it. When we look at Indian scenario, Indian space policy also talks about 2023 we came out with it. Law is yet to come. It is very eagerly awaited. why it is evenly weighted? Can anybody tell me? Why we need to have a space law? What purpose it will serve? To have a law. International career law can change.
Even we have encouraged private companies, so they gave some legislation to regulate and govern their activities.
You ask and they will say we don't need any regulation. You
No,
you
they
missed
don't.
it in the last part. The last part you missed it. Okay, anyone else? Direction was correct. Last one. You and your
Safeguard the interest of private.
safeguard the interest of investors. When liability is going to come, who will be
There should be a
liable?
balance between the benefit of the society and their business interests.
Yeah, so see what I'm saying. Just listen to me. I'm saying who will be liable if things go wrong? What will be the extent of liability? So spoke about insurance. What is the mechanism? How you are going to allow us? Is there going to be licensing regime and all? You need to look for that regulatory clarity, right? And in order to have a regulatory clarity, what do you need to establish? Huh? No, law तो हो गया. Law के through आपको क्या establish करना होगा? You need to have a regulation. So in this case, is projected as a regulator, as and when the law comes into existence, chances are that we have given them the authorization functions. Lot of the functions, whenever you get time, very soon, because we have a tendency to forget, go to InSpace website, INSPACE, right, and look at what they are doing. They are doing some very interesting work. So, space policy we have come out, and in space policy also we have spoken about extraction, licensing, and all that. So therefore, get a sense of direction when it comes to India is Bill withdrawn. So law is still in the making. Private investments, we have regulatory clarity that I have done. A recent international initiative, this also was spoken about by Nivendra in the previous session. So domestic legislation side, there is a shift. UN is again coming in, right? In what form they are coming in? They are also discussing legal aspect of space resources utilization. The working group is established. Go to their website, watch out. 5-year timeline, keep track of the developments. Some exciting developments are going to happen there, right? And challenges ahead, technology and law. Technology gives you no respite. It keeps on developing and very fast. And more private investment, more faster development. So therefore, law has to catch up. Otherwise, problems to face, right? United Nations, what kind of role UN is going to have in this world which has commercialized space, right? Will the direction of law be determined by UN-led initiative, or will it be, as I have said, through domestic legislations, or will it be, as I have said, Artemis bilateral mechanisms, not multilateral mechanisms? We have to watch out for. So keep watching as we progress further in this. I spoke about this. Domestic legislation, I have also spoken about this. One thing is very certain, and that certain thing is that space is very uncertain. Right? But look how much certainty we have brought through space technology and its applications. Your life is so certain. Our life is so certain that this device which is operated through LU satellites and constellations and all that. So therefore, very exciting future ahead. India stood for experts, both legal and otherwise. What I am telling you, those who are listening to me so carefully, at least ostensibly, there is a future here, right? And there is a cause to be served. Because when you have private investors coming in, they would look for, they will enter into various kinds of disputes, and disputes have to be settled, and in that, space lawyers will have a huge role to play, provided we have those lawyers, right? So therefore, very interesting initiative, man. I'm sure if even one mind is ignited today out of your efforts, a lot of things are taken to organize these kind of events. I think your purpose will be served and you would have addressed the cause for the nation as well and perhaps international community as well. With this, I rest my this very short presentation. If you ask me, thank you.
The technical session remains open for 10 minutes for question and answers.
For the audience. Hello. There's a implicit fate of yours in the United Nations. There is an inherent danger if we examine the American Constitution. Because the American Constitution, there is one provision that says that the President of the United States can go about doing anything extra constitutional, attack any country or kill any individual, including an American. If he perceives that the person or that country is doing anything against his nation, and he doesn't need a sanction from Congress. So this is an inherent danger for them to go astray. What do you think on that term? He will not adhere to the agreements entered into.
Very interesting examination. You may have powers. It's not necessary that you will exercise them in all the situations. If you face a rare situation, you may exercise them, but they will be rare situations. The question will be, what is rare and who decides it? When regard to exercising the power. If you look at the approach of the United Nations generally, they have taken human confidence wherever it is. It serves their purpose. But even otherwise, they have taken human into confidence. In certain situations, they haven't. What is going to be the situation in in space? Difficult to project. It will not depend on what direction we take from here. Whether it is international, multilateral, or whether it is bilateral, or whether it is purely domestic. One gets a feeling that you cannot look for sustainability in space without cooperation. It is very difficult for you alone. For example,